Welcome back, everyone. Welcome back. We hope that you each enjoyed your morning breakout session and that you had a great lunch. Really quickly, I want you to tell us in the chat, what did you have for lunch? What did you eat for lunch? I'm not even going to tell you all what I ate because you're going to be like, why are you still up there? So we hope you had a great lunch. If you went to the networking room, we hope that you made great connections there. Please feel free to check the chat because there is a Jamboard in the chat that you can access any announcements that were shared in the networking session if you didn't get a chance to go. Just an FYI, we welcome your feedback on all aspects of this conference, and we will be sharing evaluation forms after the breakout sessions and the overall conference. Later today, we will share a special incentive for those who submit conference evaluations, so stay tuned for that announcement. But we're moving right along. We're going right into our afternoon plenary session. Today's plenary is entitled Healthy Communities Through Meaningful Opportunities for Release, and our presenter is none other than Cook County State's Attorney Kim Foxx. Kim Foxx is the first African-American woman to lead the Cook County State's Attorney's Office, the country's second largest prosecutor's office. Her vision is to build the most just, equitable, and transparent prosecutor's office in the country by working proactively to make all communities safe while investing in policies to address the underlying drivers of contact with the criminal justice system. So at this time, please help me welcome her for her presentation.
Thank you so much for inviting me to participate in the 2022 Illinois Reentry Conference. I'm so grateful for this opportunity to talk about the history of parole in Illinois and the things that we need to do moving forward to ensure that we have successful reentry into our communities. I'm a firm believer that in order for us to have healthy, safe, thriving communities, we must take a holistic approach, both in coming in and out of the criminal legal system. I'd like to begin today's presentation by talking about the history of parole and early release here in Illinois. Prior to 1978, Illinois implemented what we would call indeterminate sentencing. That meant that those who were convicted of crimes were sentenced to a range of years. For example, 50 to 100 years as opposed to a specific number of years. What it gave was an opportunity for us to have a robust discretionary parole program, the ability to look at someone's progress while in detention to determine whether or not they've met the goals of rehabilitation to allow them to be released earlier, or for those who may not have met those goals to extend the time to be able to do so. Parole officials could determine whether an incarcerated person who was released early, based on an individualized review of the candidate's case, their institutional adjustment, among other things. When 1978 hit, Illinois ended its indeterminate sentencing and moved to what we call a determinate sentencing scheme, which means that incarcerated persons were sentenced to a specific number of years. So rather than that time period of 50 to 100 years, someone would be given 50 years. The end of the indeterminate sentencing and the move towards determinate sentencing also marked the end of discretionary parole. Again, the ability to be able to look at an individual's progress to determine whether or not they have met the goals of rehabilitation. Between 1978 and 1997, even though parole was limited, people could still be released early because they received what we call day-for-day time credit. So usually most people who were given prison sentences here in Illinois served only about 50% of that sentence, unless, of course, they were sentenced to life or death. However, in 1998, Illinois passed truth in sentencing laws. And what happened was it massively reduced the amount of time that incarcerated persons can earn off of their non-life sentencing. So most incarcerated people who were sentenced after 1998 must serve between 60 to 100% of their sentence. Now, the problem with this was that it reduced the ability of incarcerated persons to earn any soft or relief from their sentence, despite their rehabilitative efforts. Again, what we recognized early in the tenure was that the individualized assessment to determine whether someone has adjusted, has been rehabilitated, had been diminished. With truth in sentencing, it almost eliminated any individualized assessment of folks to be able to make a true determination as to whether or not they should be released. Currently, parole considerations are limited to 4 general categories. The first is those detained under the Juvenile Court Act and are eligible for consideration for youthful offender parole. And again, these are young people or who were young at the time that they committed their offense, and that youth is determined by the Juvenile Court Act. The second category are those who are made parole eligible through a commutation of sentence by the governor. The third category are those who are sentenced to indeterminate sentences for crimes that occurred prior to 1978, again, when we had the ability to have more discretion around parole. And then finally, those who are eligible for parole consideration under House Bill 531. Now, we need to talk about the sentencing structure because America sits as an outlier in the rest of the world in how we handle incarceration, and particularly incarceration with longer sentences for prisoners. Globally, the United States in 2019 had an incarceration rate of 655 people per 100,000. Even higher authoritarian nations, but as we all know, the United States is not an authoritarian nation, it is a democratic nation, despite what we see in the headlines these days, or at least in the last 4 years. We are a democratic nation, one in which we value human rights and dignity. And again, a country that likes to believe in exceptionalism. The problem that we find, particularly around incarceration rates, is that we are exceptionally high in our incarceration rates and the sentences that we give. For example, authoritarian nations like Russia has an incarceration of 389 per 100,000. Again, comparative to 655 per 100,000 here in the United States. And China has an incarceration rate of 118 per 100,000. We also have a higher incarceration rate than other developed nations that we would consider our peers, more democratic nations like Canada, which has an incarceration rate of only 114 per 100,000, or Germany, which has an incarceration rate of 76 per 100,000, or even Japan, whose incarceration rate is at 41 per 100,000. Statewide, here in the United States, Illinois has one of the highest de facto life sentences in the country. Approximately 6% of the Illinois Department of Corrections population is serving a de facto life sentence. And by de facto life, it means that even if one was not given life, the number of years would add up to essentially a life sentence. For example, in 2020 and 2021, 67% of de facto lifers are Black. Only 21% are white and 11% are Latinx. This is a compelling number to talk about not only the incarceration practices that are out of step with the rest of the country or rest of the globe, but also points to the disparities, the racial disparities and inequities in how we administer justice within our own country. The fact of the matter is that Blacks make up only 13% of the US population, and yet, again, 67% of de facto lifers were Black. Now, as people talk about incarceration and the purposes of incarceration, there are 2 theories that are often at play. The theory of deterrence versus incapacitation. Deterrence is the belief that by sentencing someone to a significant period of time, others in the community would see such a sentence and be so afraid of receiving a sentence like that themselves that they would not engage in criminal acts. They would be deterred from it. That the societal impact of watching others go to prison for long terms would have others have the rational thought that they themselves would not engage in those acts. But the truth is, long sentences do not deter crime. Long sentences do not deter crime. We know this because as we just went through the scheme of how Illinois, for example, has used parole over the course of the last 3 decades, we did see that violent crime rates decreased over time, but we were still seeing levels of violent crime that would suggest that the long sentence had nothing to do with others outside of the system not engaging in that behavior. What the research and data has shown us is that where long sentences aren't a deterrent, it is the certainty of being caught committing a crime that has a real impact. The certainty of being caught committing a crime is a far more powerful deterrent than the punishment that might be imposed. And let's think about that for a minute. If I think that I can commit an act and not get caught, that is more of an incentive for me to engage in the behavior. If I'm certain, for example, that the police may figure out who committed the crime and make an arrest, and that arrest and all of the attenuating factors that come with it, being detained pre-trial, having to be away from family, losing jobs, and the like, and you have a high likelihood of being caught, that behavior, that certainty is what makes people change their behaviors. And what we also know is that long sentences not only are not deterrent, but they also may contribute to recidivism. What we know is that folks who have these long sentences, who are pulled away from society and the protective factors that we know and help people make healthy, right choices are taken away in the prison system. And therefore, the longer that we have folks institutionalized, the longer that they are separated from those positive societal factors, we know that once they come out and try to reacclimate without the right support systems, a holistic support system, they have a higher likelihood of recidivism. So these long sentences don't deter crime and, quite honestly, have the opposite effect of increasing recidivism. Currently, the prison system simply incapacitates offenders. What that means is it just holds them in a corner. It prevents them from committing further crime in public right now. Incapacitation is different than rehabilitation. Incapacitation just means you're sitting where we know where you are. It is in no way dealing with the underlying reasons that may have brought someone in contact with the criminal justice system, and to ensure that once they are released, they don't engage in the same behaviors. The fact of the matter is that America and the Illinois prison system has become addicted to incapacitation and not invested in true deterrence and a holistic approach to reentry. We also know a number of things and why long sentences don't make sense. We know that when we look at peak arrest rates, for example, the 19 years old is about the time where most people are engaging in crimes of, say, for example, robbery. And that declines by more than half by their late 20s. And so you have someone, a young person who may be engaging in this behavior. And the research and data shows us that as they get older, they age out of this behavior by more than half by the end of their 20th decade. So what that means is giving someone at that age a sentence of, say, 20 or 30 years or 25 years is well beyond the time that they would have matured out of the behavior that led them there in the first place. And so we're simply, again, incapacitating and not in any way working towards rehabilitation or effective reentry because they've long since passed the usefulness of that incapacitation. Another example, murder. We find that the research shows us that 20-year-olds who are at the peak arrest rate for murders, that declines by more than half by the time they reach their 30s. For example, with rape, the age is 18. Vandalism should come as no surprise. We see that earlier in our teens at the age of 16. In crimes of forgery, fraud, embezzlement, usually these crimes are committed by peak arrest rates for those in their 20s. And again, the aging out of that occurs in a far shorter time than we see the incapacitation or incarceration rates. Again, there are various theories of why people age out of crime. Some of the things that have been studied in more recent years are around brain development. A lot of research has gone into adolescent brain development, which has shown that the brain is not fully developed until mid-20s, about 25. We also know and are looking at marital status. When one is anchored with family and supports, they tend not to engage in these risky behaviors. Diminished physical capabilities due to aging. I can attest to this as once being an avid runner, my knees aren't the same knees that I had before. And so for those who might have engaged in physical activities or behaviors in their youth, find that as they get older, they can't do that anymore. The overall point of this is that many people who are incarcerated for long periods of time can likely be released from incarceration without posing a threat to public safety, that they can still be held accountable and still be able to be released back into our communities for shorter periods of time with holistic support so that they can be healthy and thriving and not within our justice system. I want to for a moment talk about House Bill 531, which is the Youthful Offender Parole. This is the first meaningful legislation addressing parole in Illinois in decades. Unfortunately, it's not retroactive. That means that we aren't going back. It only applies to cases that have come in since the passage of the bill. And what it does is it creates a mid-sentence parole consideration for most crimes when the incarcerated person was under 21 when their crime was committed. And so what that means is that people can be considered for parole for committing most crimes after serving 10 years of their sentence. But there are some exceptions. Those exceptions are you must wait 20 years if the crime was for aggravated criminal sexual assault. Additionally, you must wait 20 years if the crime was first-degree murder, unless you're serving natural life, which would make it ineligible at all. Also, unless juveniles who are sentenced as adults, so they will not be able to serve more than 40 years of incarceration, are also ineligible. Crimes and sentences that are ineligible for parole consideration also include convictions for murdering a police officer, convictions for predatory criminal sexual assault, and natural life sentences for any crime. Next, I'd like to go and talk about an initiative that I'm very excited about, and one of the reasons I was very eager to participate in this conference. I'm part of what has been a national movement by prosecutors to do what we call prosecutor-initiated resentencing. Last year, Illinois passed Senate Bill 2129, and it became effective earlier this year on January 1st. What this bill does is allow prosecutors, at their discretion, to motion a sentencing judge or their successor to resentence incarcerated persons whose original sentence no longer advances the interest of justice. This allows for us to be able to look at those populations who had been given long sentences back as the legislatures were going back and forth of how to address crime and ramping up sentencing structures that saw people go to prison for significant periods of time in ways that we would not see them go to prison today. Illinois is the fourth state in the nation to grant prosecutors this discretionary power, after California, Washington State, and Oregon, who led the way. The Cook County State's Attorney's Office wrote and advocated for this law's passage because we recognize that long sentences without meaningful opportunities of release harm communities by taking away money from the neediest parts of our states, separating families for long periods of time, and criminalizing actions that stem from larger societal issues like poverty, dispossession, and other structural issues related to race and class that we know are contributors to violent crime. I'm very excited about this legislation having passed and the ability for my office to be able to circumvent a system that was designed not to rehabilitate and garner reentry, but solely to incapacitate. And again, as we talked about the statistics earlier, the communities that were most impacted by these failed policies were Black and Brown communities, and those particularly that have been impacted by disinvestment and other failed social policies for years. It's incredibly important that we do this work, and it's incredibly important that prosecutors who for so long were the ones who were in courtrooms asking for long sentences, not necessarily without rhyme or reason, mostly driven by retribution or some sense that it would keep our community safer, only to find ourselves, as we do right now, continuing to grapple with the issues of gun violence in our communities. Too many lives lost, and not enough emphasis and focus on those things that are driving violence, and not enough energy and focus on making sure that people who come out of the criminal justice system aren't going back and are finding ways to be healthy, safe, and thriving and contributors to our communities. So some of the work that we're looking at, are people who have served at least 10 years of a sentence for a drug-related offense, people who are currently 65 or older and have served at least 20 years for a non-sex or non-homicide offense, people who were under 21 at the time of their offense and have served at least 15 years for a non-sex and non-homicide offense. We're also looking at people who've served at least 10 years for a theft or a robbery offense. And again, we're looking at these folks to go and say, is it time to have those sentences revisited? The Cook County State's Attorney's Office cannot request resentencing for people who have not served at least the minimum sentence for their crimes and who are currently serving mandatory sentences, for example, mandatory life sentences. So where do we go from here? As I've already said, decades of tough on crime policies have had horrible, horrible effects on communities. The most obvious effect is the separation of families. And it's not simply the separation of families in the immediacy. There are generational impacts when we send a parent to prison and what that means for that child and their children. And we have to be mindful and cognizant when we use the lever of incarceration of knowing that it's not just one person, it's a family, it's generations, it's a community. We also know that these horrible tough on crime policies have been burdening financially struggling families of incarcerated persons with the costs associated with incarceration, prison visits, phone calls, adding money to books, legal fees. We also know that there are adverse factors that impact family members, the increased risk of obesity, mental illness, heart attack, stroke. And again, for women of incarcerated persons, we see these more acutely. For children, there's increased risk of engaging in risky behavior. They've been shown to have worse physical outcomes, for example, high cholesterol. We see a number of young people engaging in criminality and not being able to complete high school. Many have engaged in early parenthood and have lower financial earnings. Again, generational impacts. And for communities generally, we see increased child poverty rates. We see higher instances of sexually transmitted diseases, negative impacts on lung health, the reduction of a household's economic resources, which cripples the economic mobility in neighborhoods already struggling with poverty. I say all the time, it is no surprise to me that the communities in Cook County that have the highest levels of violence and the highest levels of incarceration rate also have the higher levels of unemployment, higher levels of economic disinvestment, higher levels of health morbidities that don't exist in communities in which incarceration rates aren't the same. As I said earlier, prosecutors have played a large role in securing these long sentences, which means that prosecutors have played a role in helping weaken the community's health. It also means, most importantly, that prosecutors should play an equally large role in trying to reduce sentences and right some of the errors of the past. That is our obligation. And that means not objecting to parole or clemency for appropriate candidates. We must disabuse ourselves of the practice of simply saying no to every case that comes across our desk. We must be thorough and thoughtful in evaluating each individual so that we are providing a recommendation for parole or clemency that meets that individual needs. It also means using the discretionary power that has been afforded to us by Senate Bill 2129 proactively to resentence those who have served long sentence. And then, as you all know, it's the focus of this conference, once released, we should work to ensure that returning citizens are given every opportunity to fully and successfully reintegrate into society. Some of the things that we could and should be doing are working on criminal records clearing, the ability to expunge, seal, or receive gubernatorial pardons where appropriate so that the collateral consequences of having been justice involved do not continue to burden returning citizens and disenabling them from being able to fully reintegrate. We also must ensure that there are job opportunities for returning citizens, the ability to secure jobs that will provide for both short-term and long-term needs. We know, as I said earlier, that incarcerated people were among the poorest in the country prior to their incarceration. And we also know that that is a factor that leads to some measures of criminality. We cannot have people come out of the same system and back into the same conditions and expect different results. My grandmother would call that crazy. And yet, for far too long, our criminal justice system has tried to expect different outcomes by doing the same things that got us there in the first place. And therefore, we must ensure that people who are coming home have the ability to make a living wage to provide for themselves and for their family. And we know that by doing so and by clearing these records, it will absolutely give the opportunity for not only the returning citizen, but their family and their community the ability to grow. Safe, affordable housing is also critically important. Not only having a job, but the ability to have a home in which to take care of oneself and one family. We know and we have seen increased levels of homelessness, especially among returned citizens, which again impacts their ability to secure employment, access public benefits, and fully reintegrate into society. And lastly, we know that access to quality and affordable health care, including and especially mental health care, is essential for ensuring that those who have come out of the criminal legal system are able to regain their full health. Let's make no mistake. While we recognize that there must be accountability for acts that happen in our communities, we ought not be engaging in patterns and practices that make those matters worse. We know that being in prison is a traumatic affair, and maybe something that we often don't talk about enough. And for those who have had their liberties taken, for some who have had to sit in isolation, for those who have been deprived of those things that keep us healthy and happy, like pro-social care, prison can be devastating, and the return home can be rocky. And so we must make sure that we have adequate mental health care to meet those needs, in addition to dealing with the day-to-day burdens of life, even if one hadn't gone to prison. And so we must make sure that we have an agenda for the returning citizen that is holistic in its approach, that recognizes that, again, criminality is often rooted in underlying issues of poverty and structural racism, and do everything that we can to ensure that we are dismantling systems that we know hurt, that we're actively righting the wrongs of the past, and that we see the value and opportunity of everyone who comes home and invest in them like our communities depend on it. Once again, I want to thank you for this opportunity for participating in this year's Reentry Conference, and thank you for your efforts to highlight the need for us to take this broad community holistic approach to reentry in our communities. Thank you for this opportunity.
Well, that was an amazing Great presentation. A powerful way to start off our afternoon. So many power nuggets and tips in there. And Cook County State's Attorney Kim Foxx was scheduled to be here with us to do a live Q&A. However, we were notified this earlier today that she is under the weather and she will not be able to join us for live questions. However, as the old saying goes, proper planning prevents poor performance. And we were able to pre-record her session so that we could still have her here with us to give us what she did today. So with that being said, we would like to thank you, Cook County State's Attorney Kim Foxx, for sharing with us today. And thank you for your leadership and your transparency on what healthy communities look like through meaningful opportunities for release. And we also are wishing you all the best and a very speedy recovery. So with that being said, we are moving right along. I have so many things I could say from that, but so powerful. One of my favorite things about the conference is the variety of speakers that we are able to bring to you all. And so I feel rejuvenated. It makes me feel rejuvenated to be able to do this important work. And we hope that you all are feeling the same. So we will now proceed with our afternoon breakout sessions. Again, there are going to be three sessions that you will have the opportunity to select from. So please select the one that you wish to attend by reviewing the breakout room descriptions. Immediately following those sessions, you will report back here to the main stage, and we will be having a very special presentation by two artists beginning at around 3:05. So at this time, you can proceed to your breakout rooms, and we will see you back here in a little over an hour. So make sure that you enjoy. See you soon.